Hello, everyone. Looks like we've got people coming in. I'm just going to give it a few minutes. I know some people have to download the Zoom software to view the video, so we'll make sure that everyone's here before we really begin. Okay, I think we're about ready to begin. Welcome everybody to the Authors Guild's webinar, Estate Planning for Authors. Our guest today is the expert attorney Ed McCoy, dear friend of the Authors Guild. Glad to have him here today. I'm going to go ahead and turn it over to him and we'll get started. Here you go, Ed.
Okay. Okay, thanks, Johnny. Can you see now my full screen, the cover page of my slide deck?
No, I see you, Ed.
Okay, let's see. I'm going to try share again. Okay. So let's see here. Does that do it? Okay, it says select a window of or application. Oh, here we go. Here we go.
Yeah, it's tricky. You got it.
There it is, right? Okay, now I'm going to go into slideshow mode. Okay, how's that?
That's perfect, Ed.
Okay, great. Okay, thanks again. And I'd like to thank all of you joining the webinar today, as well as everyone who accesses the recording later. As Johnny said, I have a long-standing relationship with the Authors Guild. I served as director of legal service. I worked there for a number of years and eventually served as director of legal services. And after that, I went to the Association of American Publishers, followed by McGraw-Hill, and now I'm in private practice. And I really consider myself very fortunate to be involved in the book industry and to have the ability to work with people like you. As every author knows, there's something magical and even transcendent in the experience of sharing stories, information, and ideas by way of the written word. Each author's expression is unique and personal to them, and something that carries great meaning, not only for the author, but also the author's readers. So while estate planning is important for every adult, for authors, there's this whole additional dimension of ensuring that the fruits of your lifetime creative work, namely your creative property, are managed the way that you want after you one day pass away. For a little levity, I'm going to quote the comedian George Carlin, who said, "I'm always relieved when someone is giving a eulogy and I realize that I'm listening to it." Joking aside, though, estate planning really can be empowering and create a sense of well-being because it enables you to provide for your loved ones and make determinations about how your property is to be distributed after your death. And then for authors, ensuring that your literary estate is managed appropriately. I'm going to start this webinar by giving an overview of a few key estate planning vehicles or instruments. And I have a lot to get through in terms of my slides and my prepared remarks. So if you would just bear with me until the end, and then I will be answering your questions. And I encourage you to send them in at any point during the talk. And in a little bit, I'm going to get into the author-specific discussion, but I think it will be helpful first for me to provide this general overview of estate planning instruments, which will provide some context for the author-specific discussion. Although there are US tax laws to take into consideration, estate planning is primarily governed by state law. So I'm licensed to practice law in New York State. And by way of example, I'll be discussing a few of the rules in New York, but those are only intended to be examples. This talk is meant to be a general one and not specific to authors in New York. A very common estate planning document is, of course, a will. In New York, we call a person who makes a will the testator. And the testator, when determining how to distribute property under the will oftentimes give property outright at death to beneficiaries, beneficiaries being the people named to take property under the will. There may be other instances where the testator wants to have property held in trust after the testator's death for one or more beneficiaries. So for instance, there might be a beneficiary who has a disability and his particular disability prevents him from managing his own assets effectively. Or there could be multiple underage beneficiaries, or sometimes a trust is set up under a will for estate tax planning purposes. The will also state whom the testator names to serve as executor or co-executors under the will. And an executor is usually empowered to collect the probate estate. The probate estate refers to the property of yours that passes under your will, if you have one, other than passing by way of other mechanisms. And the executor will use the estate property to pay estate debts, taxes, and administrative expenses. Oftentimes, the executor is also empowered to sell estate property in his or her discretion, such as real estate or valuable personal property. And then ultimately, the executor distributes the net probate estate out to beneficiaries or a trustee in accordance with what the will provides. As an alternative to a will, some people opt to set up revocable living trusts. A trust that you create during your lifetime, as opposed to under your will, is called a living or inter vivos or lifetime trust. And revocable means that you can always modify the trust during your lifetime, or even revoke it entirely, shutting it down and taking back whatever assets remain in the trust at that time. In New York State, a revocable living trust can be created by way of a written agreement between the grantor. So the person who creates the revocable living trust is known as the settlor or grantor. So an agreement between the grantor and at least one trustee of the trust. In New York, during the grantor's lifetime, the grantor can also serve as the trustee. So the idea there is the grantor creates the revocable living trust. She funds the trust, as it's called, with her own property by transferring title to the property into the trust. And then as trustee, manages it for her own benefit as the lifetime beneficiary of the trust. And then after the grantor dies, a successor trustee, also named in the trust agreement, would step in and do one of two things. One would be to distribute the trust assets to remainder beneficiaries named in the trust agreement, if that's what the trust agreement provides. Or if the agreement provides instead, the trustee would continue to manage those assets in trust for the remainder beneficiaries. A common reason why people set up revocable living trusts is to avoid probate. Probate refers to a process whereby a court is petitioned. Now, it's sometimes called a probate court or a surrogate's court. In New York, it would be the surrogate's court in the county where the person who made the will was domiciled at the time of their death, meaning where they had their place of permanent residence. And the petitioner is typically the executor named in the will. So the executor petitions the probate court to do two things. One, find that the will is valid, that it was executed in conformance with the various formalities required by state law, that the testator understood the nature of what he was doing when he made the will, and so forth. And secondly, the court is petitioned to formally appoint the executor named in the will to act. Now, a probate proceeding can sometimes become drawn out and costly if one or more family members challenge or contest, as it's called, the validity of the will. However, most probates are not contested, and the court empowers the executor to act and finds the will valid within a relatively short period of time. But if there are heirs, family members, who for some reason you believe would be likely to contest your will, then a revocable living trust may be a good idea. The reason is that a probate petition almost invites certain people, if they are dissatisfied in some way with what the will provides, to contest your estate plan, to contest your will. So again, as an example, in New York, the petition is filed with the court, but in order for the will to be probated, we call them distributees in New York. These are family members who, if they survive the decedent, the person who died, and there were no will, they would be entitled to a share of the estate property passing under the laws of intestacy. A person who dies without a will is known as having died intestate. And so jurisdiction needs to be obtained over these people by way of them being served with a citation and a copy of the will, and otherwise they can waive citation and consent to the probating of the will. But if, let's say, they were left out of the will, or maybe they got something but less than their siblings, or whatever the case may be, they might be inclined to contest the will on some basis with regard to, again, the formalities or the capacity of the testator to have made a valid will, and so forth. On the other hand, if you create a revocable living trust, then the property contained within the trust can be administered by your successor trustee upon your death without the need for any court proceeding. Another reason people sometimes opt for revocable living trust is that because of these jurisdictional requirements, there may be a problem notifying heirs. Maybe certain family members are missing or scattered geographically and would be hard to locate. Also, in New York, when a probate estate includes real property outside of New York, and the classic example for New Yorkers is what we call snowbirds. So a person who is domiciled in New York but spends the winter time down in Florida and maybe owns a piece of real property in Florida where she stays when she's down there. And then when that person dies, her executor in New York, in order to collect the Florida real estate into the estate and administer it, needs for an additional probate proceeding called an ancillary probate proceeding to be brought down in Florida at additional cost to the estate. Whereas if instead the person had deeded the Florida property into her revocable living trust during her lifetime, then the trustee at death could immediately administer the Florida property. Also, some people opt for revocable living trusts for privacy. So typically, when a will is offered for probate, it is made publicly available for inspection at the courthouse. And there is no similar requirement for a revocable living trust. So revocable living trust agreements can be kept private. And finally, a trust can provide for the grantor's own care if she eventually reaches a point in her life where she can't manage her assets as effectively as she was able to do in the past. So a successor trustee can step in at that point and do things like use the trust assets to pay the grantor's bills. However, when people make a will, they will often at the same time grant a power of attorney to a loved one, such as a spouse or child, and the attorney, in fact, the agent under the power of attorney, can perform the same functions. So a trust is not the only tool available. And while I've just stated a number of reasons why a revocable living trust may be desirable for a number of people, a will is often a completely sufficient means of transferring property at your death. As I mentioned before, most probates are not contested, and furthermore, it's not necessarily more expensive to have a will and probate than to have a revocable living trust. Either way, you are going to need an attorney to draft the revocable living trust agreement if you opt for one, or the will. And in fact, it's usually advisable when a person creates a revocable living trust for them to also make what's called a pour-over will, in case the person inadvertently doesn't transfer certain of his property into the trust during lifetime. And such property can be poured into the trust by way of the will. So in either case, the attorney will need to draft documents, and then the guidance of attorneys is going to be needed either for a trustee or an executor in administering the estate after the person's death. And either a trustee or executor will need to pay accountants or attorneys to prepare and file fiduciary income tax returns for the trust or the estate. And unless the trust agreement or the will provides otherwise, at least in New York, trustees and executors are both entitled to commissions by statute as a default. So the bottom line is that a revocable living trust or a will one is not inherently better than the other, in my view. And so you really need to look at your specific circumstances and wishes and talk to your legal counsel when developing your estate plan to make a determination about what you want to do. I'll also mention here a couple of other ways that property can be passed outside of a will, so without the need for probate with respect to that particular piece of property. One is called joint tenancy with rights of survivorship, or where a married couple owning a piece of real property is concerned, it's called a tenancy by the entirety. But regardless of the designation, what this means is, let's say you have two people who own a piece of property as joint tenants with rights of survivorship. Well, when the first of them dies, the other person becomes the complete 100% owner of that property by operation of law. Also, especially with things like bank and brokerage accounts, somebody who owns an account 100% themselves can designate a POD, or paid on death beneficiary, to take ownership of the account after the death of the owner. This information is recorded with the financial institution as a directive to the institution to distribute the property at death to the primary beneficiary, such as a spouse, if that person is living at the time the account owner dies, or if the spouse has predeceased, meaning has died before the account owner, then there can be secondary beneficiaries who are named, such as children. Now I've set the table, so let's talk about literary works. A key consideration when you're an author is, who is going to have or develop a knowledge, appreciation, and passion for my creative property, and administer the rights to those properties in a thoughtful and productive way. This person or entity could be a friend, it could be a family member, it could be an organization like the Authors Guild, or you may want to designate a literary trustee to engage in the management of your literary estate on behalf of beneficiaries whom you also name, such as family members, for instance. A literary trustee can be empowered to do things like issue licenses for the use of your work and collect the royalties and other revenues from such agreements. Exercise any contractual rights to terminate copyright licenses. make determinations regarding any unpublished manuscripts, such as whether to have those manuscripts published after your death, and manage online properties like your author website. And then if there are areas where you don't want to give complete discretion to your literary trustee, you can leave behind written instructions. So how do you set up a literary trust? Well, that takes us back to the overview of estate planning instruments that I discussed a few minutes ago. One way would be to create a revocable living trust dedicated to your literary properties. So you would create the revocable living trust during your lifetime, and you can act as you can be the grantor, the beneficiary, and the trustee, and transfer title to your copyrights and associated contracts and so forth into the trust by way of yourself as the trustee. And then you would manage the property the same way that you manage your author career right now. And then after your death, a successor trustee whom you name would take over that responsibility on behalf of the remainder beneficiaries of your revocable living trust. The other way is by having a testamentary trust, creating the trust under your will so that it doesn't come into being until after you have passed away. And at that point, the trustee named in the will act. And all else being equal, if all other considerations are equal, you may sometimes, and I don't want to overemphasize this and create panic, but there's something I'm going to talk about in a lot more detail later called statutory termination under the US Copyright Act, where in some instances, an author and sometimes an author's heirs can, many years after an author makes a grant of copyright interests, can terminate that grant and take back those rights. And copyright termination, statutory termination, does not apply to transfers made under a will, but does apply to a lifetime transfer of copyright interest to a trustee. Now, a lot of people will say, I'm not worried about my heirs defeating my estate plan with respect to my copyrights. My spouse wouldn't do that, my kids wouldn't do that, but other people may have a different relationship with their heirs. Also, depending on timeframes, there could be a scenario where under the Copyright Act defines who controls an author's termination rights after the author's death. It's independent of what an author does in, say, his will. So there could be a scenario where you have a multitude of grandchildren who are in possession of the statutory termination rights. So I just say that to point it out to you, not to say that it's necessarily going to be a big concern. But right now, I will give you an example of creating a literary trust by way of your will. So as I said, your will would provide for your literary estate to go into this testamentary trust. You would name a trustee who would manage that property for beneficiaries. And you could give the trustee discretion to hold on to the monies that come in by way of your publishing and other agreements, the royalties and so forth, could hold on to those monies for indefinite periods of time within the trust, such as to invest them and grow the size of the trust corpus for the benefit of your beneficiaries, or maybe to engage in future marketing and promotional activities with respect to your creative property. Or on the other hand, the trustee could distribute out the net monies in the trust account on a fairly regular basis, such as toward the end of each calendar year, to your beneficiaries after various expenses are taken from those monies. I mentioned before potential legal expenses, fees to accountants, and then more ordinary everyday costs like printing, shipping, travel costs for the trustee, and so forth. And then finally, the trustee typically receives compensation. There might be default compensation by statute, or you could state in your will what the trustee's compensation will be. And considering the nature of the property being managed and what a literary trustee does, something akin to a book agent's commission might be appropriate for your trustee's compensation, such as 15% of all royalties and licensing revenues brought into the trust by the trustee. And then on any income from the monies in the trust accounts, like dividends and interest, 15% to the trustee on those monies as well. And it's important to have mechanisms for successor trustees to eventually step in. So a literary trust can potentially last for a very long period of time. So you could name one or more successor trustees to serve in the event that the first literary trustee can no longer act or has to resign for some reason because their life changes and they don't have the time in their schedule to do it anymore or what have you. But also, many years in the future, you might not be able to foresee who the most appropriate people would be to serve as literary trustee. So you could also have a provision allowing whoever is acting as trustee at that time in the future to name a successor before stepping down, or to name a co-trustee, and then the two trustees would serve together until one of them stepped down. And finally, for a scenario where there is no trustee acting, you could say at that point, a majority of your adult living beneficiaries of the literary trust would have the ability to name a successor. Okay, so creating a literary trust is, as we've discussed, different from giving your literary estate outright to beneficiaries. And one reason to do that is there's somebody with the skills and enthusiasm to perform that task. Maybe everything else being equal, there's one person who has more time in his schedule to devote to this responsibility. But also, you may want to do it for the purpose of streamlining decision-making. So let's say, hypothetically, you have 3 children, and you want those children to be the financial beneficiaries, if you will, of your literary estate. So one option would be to give your literary estate outright to those beneficiaries to hold as joint owners. But they might encounter some disagreements thereafter about things like whether to terminate a particular publishing contract because the book has gone out of print and there's an out of print clause, or they've gotten rights back and they're trying to pick a new publisher to republish the book and they can't decide on which one, or they have disagreements about other intermediaries to work with, or they can't agree on cover art, or any number of other potential disagreements. So you might instead opt to put all of that decision-making authority in the hands of one literary trustee who will make those decisions on behalf of all of your beneficiaries as the beneficiaries of the trust. Okay, so if you make the choice to have a literary trust and a literary trustee, the appropriate time duration, the term of the trust, could very well be until 70 years after your death. The reason being that most copyrights nowadays last for the life of the author plus another 70 years. So the idea would be, as long as you have copyrights still in effect, the trust will continue and the literary trustee will continue to act. Now, I would also recommend considering having a couple of other provisions in your literary trust instrument. One is, let's say that after your death, your literary trustee is having a great deal of success in generating new readership for your works and generating interest and finding new licensees and so on and so forth. But then some time much later, maybe 40 years later, the successor trustee is not having the same level of success and isn't really able to generate much in the way of revenue and so forth. And can't seem to find any avenues. But then a worthy and deep-pocketed buyer comes along that has a keen appreciation for your creative works and ideas as to how to breathe a second life into your literary estate, such as by creating adaptations or in other ways. Well, at that point, your successor trustee might deem it in the best interest of your beneficiaries and your literary legacy to make that sale and distribute the net proceeds from the sale to your beneficiaries and close down the trust at that time. Secondly, there is a rule that exists in a number of states. It's extremely arcane, and I'm not going to torture you with the details of it. It's called the rule against perpetuities. The only thing I will say is that where it exists, the rule against perpetuities is intended to prevent a trust from just living on and on and on from one generation to the next without any defined limit on how long the trust can last. So when creating a literary trust, you'll want to talk to your legal counsel to make sure the attorney incorporates provisions into the trust instrument so that by its own terms, the trust cannot last longer than the time period permitted by the applicable rule against perpetuities, if any. I've just said a lot about literary trustees, so I'm going to spend a moment here also talking about literary executors. As I mentioned before, when a will is probated, the executor engages in a series of steps, collects the estate property, pays debts, taxes, and expenses, and ultimately makes distributions in accordance with the provisions of the will. Now, in New York State, an executor is appointed for life, but the executor usually completes her responsibilities within a much more finite period of time. Maybe completes the administration and makes distributions out to beneficiaries within 2 years, or a little longer than that, or less than that. But ultimately, once that happens, the executor's work is for the most part, or essentially finished. And if you have a literary trust provision in your will, then your literary estate is transferred, is assigned at that point to your literary trustee. But until that happens, someone else needs to deal with your publishers and collect your royalties and do all of those types of things that the literary trustee will ultimately do. And by the way, the literary executor that you name, you might also name the same person to be the literary trustee. So it's a question of chronology of the roles. Whether you grant your literary estate at death by way of a will or a revocable living trust, you also have to consider what you want your literary estate to be comprised of, what it is that you want to give. So here is a sample list. It could include, and this is a person bequeathing, meaning giving under a will their literary estate into a trust to be managed by a literary trustee. So all copyrights to the author's books and manuscripts, whether published or unpublished, completed or not completed. Any other intellectual property rights that you hold, such as, let's say that during your lifetime you've published a book series, and perhaps the title to the series is entitled to trademark protection. All rights to any other fiction or nonfiction writings that you also want to include as part of what you give. So this could encompass poetry, newspaper and magazine articles, blog posts, screenplays, or anything else that you may have written that you want to include. All rights to any adaptations and derivative works based on your literary work. So perhaps audiobooks, graphic novels, foreign translations, merchandise, film and television adaptations, stage plays, or any other derivative works. And this can include both derivative works that have been created during your lifetime or your rights under the agreements to create those literary works, those derivative works rather, and also the right of your literary trustee to create or grant rights to create future derivative works. Referring to all of the foregoing as your creative property, you may also want to give various documents relating to your creative property. So things like manuscripts in print or digital format, which can be important for having a work published. And if you've done self-publishing, any print production files or XML or HTML tagged ebook production files that you may have in your possession. And then with regard to traditional publishing or otherwise, your publishing and other agreements, your correspondence with your agent, publishers, and other licensees, any marketing materials or plans in your possession. To the extent that any of these documents are stored digitally, your usernames, passwords, and any other authentication information needed to access the documents. And with regard to physical print documents and materials, I recommend, as much as is reasonably practicable, putting copies of all of these documents in some unified location, like a set of drawers or boxes, and then labeling the boxes, drawers, as being intended to go to your literary trustee, say, or your outright beneficiary. And then in your will, you would not have to itemize each and every one of these items individually, but in a more categorical way, you could say what's in that location and note that it's been labeled as going to the literary trustee, intended to go to the literary trustee under your will. Separately, there may be some physical items that you want archived for the public record. And that could include, again, perhaps original copies of manuscripts. Maybe there's some personal correspondence that you would want to make publicly available, any research that you've developed, and the institution of higher education where an author earned his undergraduate or graduate degree, or a community association or historical society in the community where he lives, perhaps. One of these entities might have the ability and interest in performing this archiving function, making these materials available for access by researchers and other members of the public. And you'd want to state very clearly that you're only giving the physical documents, not the underlying copyrights to those documents. As for whom to give your literary estate, you may not always need to give it to a literary trust. So let's say that you're married and you are survived by your spouse. Well, maybe your spouse has sufficient interest in book publishing and in performing this role for you to give your literary estate outright to your spouse at death. And then your spouse would receive, as the outright beneficiary, the royalties and so forth from the distribution and sale of your literary properties and other creative properties. And if you're not survived by a spouse, maybe you have an only child to whom you would want to give your literary estate outright. Some of the members of the Authors Guild have bequeathed their literary estates to the Authors Guild, which obviously has the skills and expertise and contacts in the book publishing industry to manage literary estates, and of course does so with a great deal of care and respect for the literary legacies of its members. And as I understand it, you can also opt to give your literary estate to the Authors Guild Foundation. And if you give to the Guild, then the monies generated would fund the Guild's mission, or if you bequeath your literary estate to the foundation, then the monies would support the foundation's mission. Also, you can have contingency provisions, such as I give my literary estate to my spouse if she survives me, or if she doesn't, then to my daughter, or if neither of them survives me, then to the Authors Guild, perhaps, or a literary trustee. It's really your decision. Earlier, I mentioned statutory termination rights. So these are provided for under sections 203 and 304 C and D of the US Copyright Act. Section 203 applies to grants made on or after January 1st, 1978, and Section 304 applies to grants prior to 1978. Both provisions bear a number of similarities, but since 203 applies to the more recent set of grants, I'll discuss 203 in detail. And when Congress provided for statutory termination rights, it understood that authors and other creators, when they make a grant, including their copyright interest, are often in an inferior bargaining position. So you think of when you entered into your first book publishing agreement. You were not in the same bargaining position that you might be years later when the marketplace has demonstrated your works to be very valuable and you can get better terms. Now, under 203, there is a 5-year window when a termination can be effectuated. And for most of you, I think that's going to involve grants of rights that include the right of publication. And publication, by the way, is broadly defined. It includes things like publication of copies of books, distribution of music CDs of music, distribution of copies of film or television programs for public performance in a movie theater, on television, and so forth. And where the grant includes the right of publication, then the 5-year window begins the earlier of 35 years after first publication pursuant to the grant, or 40 years after the date of the grant itself. To effectuate this termination, the author, or sometimes the author's heirs, must serve a written termination notice that complies with various requirements promulgated by the US Copyright Office on either the assignee or the assignee's successor in interest when that's the case. So let's say that you enter into a book publishing agreement, but then later the first publisher assigns the contract to a second publisher, or maybe the second publisher acquires the entire business of the first publisher. So in that case, the second company is the successor in interest upon which you would serve the notice. Now, where this gets real, and by the way, as the slide points out, Section 203 does not apply to work for hire agreements. It doesn't apply, as I mentioned before, to transfers of copyright interest made pursuant to a will. It does not apply to grants of foreign rights, like the right to publish your book in other countries other than the United States. And where you have made a grant that includes the right to create derivative works, termination does not enable you to withdraw the ability of the grantee or its successor to continue to use and sell the derivative works that have been created prior to termination in accordance with the provisions of the agreement that you entered into. But other than that, the grantee can't make new derivative works after the effective date of termination, and those rights revert to you, the author. Okay, so I'm going to give you a hypothetical here. Let's say that I'm an author and I enter into a publishing agreement with Penguin Random House for a novel of mine, and then years later I die. And under my will, I give to a particular charity all of my copyrights and all of my contractual rights flowing from my copyrights. But I did not during my lifetime serve a statutory termination notice on Penguin Random House with regard to that publishing agreement. And then I'm survived by my wife, and I have 3 kids, but let's say for simplicity's sake, I have 2 kids. And both of my children and my wife survived me. And the time window, let's say, hasn't yet expired for the service of a statutory termination notice on Penguin Random House. So in that scenario, my wife and at least one of my children could band together to serve that notice. The heirs need to control at least 51% of the rights. In that situation, my wife would have 50% and my two kids would each have 25%. So could serve a termination notice on Penguin Random House and get back those rights and take them for themselves and the other child. And the charity would lose the royalties from the Penguin Random House agreement and would lose any future interest in those rights that were the subject of the agreement. So the heirs could defeat my estate planning intent with regard to those particular rights. And as I mentioned before, it becomes perhaps a larger issue where I granted all of my copyright interests to a literary trustee during lifetime. Now, if instead the time period had started where I, as the author, could send a valid notice of termination to Penguin Random House, and if I had sent that notice, then the future rights that would revert from that agreement would have already vested in me at the time I sent the notice. So they would come back to me, or if I died before the effective date of termination, they would go to whomever I provided for in my estate plan, which in this case would be the charity. So again, like I said before, I'm only giving you this information to provide you with the landscape and a basic understanding of these rather complex statutory termination rules vis-a-vis heirs and so forth. But it's not meant to say you shouldn't do a revocable living trust. It's only that the issue of the ability of heirs sometimes to terminate grants based on the rights that the Copyright Act gives to them as successors to the termination right could sometimes be a factor for some authors. I also said that I was going to come back to the subject of digital assets. And I want to tell you a story here. But back in 1990, the musical composer Leonard Bernstein passed away. And he was said to have been working during the last 2 years of his life on his autobiography and was preparing the manuscript using a word processing program. And it's since been reported that because he password protected the file, no one has since his death ever been able to access the file, and Leonard Bernstein's autobiography has gone unpublished. And you think about nowadays how much more ubiquitous digital technology has become in our daily lives. We use it for online banking and accumulating consumer rewards, sometimes engaging in stock trades, emails, and engaging in communications with friends and family by way of social media, and a whole spectrum of other things, of course. And then authors are using digital technology to prepare manuscripts, to launch author websites, and to promote themselves in a variety of other ways online. So it's important for every adult making an estate plan, but very important also for authors, that your estate planning instrument be clear and explicit as to whom you are giving these digital assets to, and you're empowering your fiduciary, your executor, your trustee, to collect and administer these assets. So using the example of an author website. Now, in New York, when a will is probated, the court issues what are called letters testamentary to the executor. And where there is a literary trust, or any trust rather, under the will, then the court issues what are called letters testamentary to the trustee. And the purpose of the letters is, say, for the executor to present a certificate of the letters testamentary to the decedent's bank to demonstrate that the executor has the power to collect that asset into the estate. And if an executor or trustee goes to the service provider that was hosting your author website, the service provider is probably at a minimum going to want to see the letter of appointment, a copy of the author's death certificate, and potentially the estate planning instrument itself. If it was a revocable living trust, then a copy of the trust agreement, or a will, then a copy of the will. And that's at a minimum. Some service providers also want a court order directing it to give this access or transfer this property to the fiduciary so that the service provider knows it's not running afoul of any laws. And the court will look to your estate planning document as instructive as to whether to grant such an order and the scope of access that the court will compel. Now, this next slide is to, oh, and also I should mention that you want to leave behind for your fiduciary your usernames and passwords to access these accounts and documents and so forth. Okay, so this slide has a list of various service providers, and this is to show how their policies can differ in this area. So GoDaddy is a major provider of website hosting services and internet domain name services. And GoDaddy will cooperate with a fiduciary who provides the type of documentation that I just described. WordPress, the provider of blogging services, will do the same. However, other services will not transfer an account to a family member or a fiduciary upon the account owner's death. So a number of people here will know the service Goodreads. It's a social media site dedicated to authors and their books and is used by authors and readers. And there are kind of two ways that an author can be present on Goodreads. One is what's called an author profile. And this is where the author merges his author presence with his user profile. Now, I am a Goodreads, I have a user profile on Goodreads, and I have a bookshelf with digital copies of the covers of books that I've read, and I can star rank books, and I can write book reviews and connect with other Goodreads users and so forth. So an author using the user profile as an author to promote herself, this would be called an author profile. And when an author dies, Goodreads is not willing to transfer the author's profile account. The thinking on the part of Goodreads being it would be inappropriate for somebody other than the author to engage in those user profile functions like star ranking other books and writing book reviews of other people's books and those sorts of things. However, there is also something called Goodreads pages. And this is kind of like Wikipedia, where multiple people can populate and edit and update a page, in this case, dedicated to a given writer. And let's say that a loved one wants to update the author page dedicated to a Goodreads author. Well, that family member can become what's called a Goodreads librarian. And you can become eligible for this by posting at least 50 books from any authors on your Goodreads user profile, and then apply to Goodreads to have these editing privileges to update the author page. Twitter apparently will not transfer an account under any circumstances, and then Facebook also has kind of two sides to it. So one is what I call the social side of Facebook, which many of us are familiar with, where it's called a Facebook profile, where you have your profile picture and you can make Facebook friends and post pictures of your travels and your family members and what you had for lunch, and you can like your friends' posts and those sorts of things. So many authors use their Facebook profile as their author presence on Facebook. But when a Facebook profile account owner passes away, during her lifetime, she can designate what's called a legacy contact, somebody to manage the profile after the author or other Facebook owner dies. And at that point, it becomes a memorialized account. But the legacy contact is limited in what he or she can do. They can change the profile picture, they can accept new friend requests, they can post testimonials and tributes to the deceased Facebook profile owner, they can allow other people to post tributes. But other than that, there's not a whole lot the legacy contact can do. Now, the other side of Facebook, I call the more business-oriented side, called Facebook pages. And these are pages dedicated to a given brand, business, organization, and the like. And so some other authors use Facebook pages as their author presence, perhaps just for themselves as an author, but potentially also for Facebook pages dedicated to their individual books. And an advantage with Facebook pages is the author can be the technical administrator of the page, but can also appoint other people as additional administrators. And then if the author eventually dies and those other administrators are still active, they can continue to update and keep active the Facebook page with all of the same technical privileges that they had during the author's lifetime. And then finally, you could have someone close to you, your agent, your publisher, a family member, or a friend, set up a fan Twitter feed or Facebook profile or page on some other service dedicated to you as a writer. And then there's no concern about transferring control of and ownership of your account after your death, because this would be an account operated and owned by that other person or entity. In conclusion, I'd like to quote another comedian, Ellen DeGeneres, who said, "Procrastinate now, don't put it off." And I think that's a very apt quote for today's discussion. If you don't already have an estate plan in place, or in light of the topics I've just talked about, need to update your estate plan, which I think will be the case for a number of people, then I encourage you to do so sooner rather than later. You will feel good that you did, and it's obviously a very important thing to do. So again, I thank you, and let's go to questions.
All right, looks like we've got a few questions submitted. You see where they are, Ed?
Yeah, let me put on my glasses and take a look here. Okay, so let me just kind of eyeball these and okay.
And Ellen, I think you had a question. If you look for the Q&A button, Ellen, you can submit a question there, and Ed can see them.
Okay, I'm going to read this one out loud. I'm just trying to piece this together. So, I am an authorized Bonanza novelist, which is a licensed product. For my newest editions, I sent a document with percentage I'm paying, plus an agreement to turn over both books to Bonanza Ventures when I die. The Bonanza lawyer has not executed this document. Is there a reason this isn't a good or executable idea? Okay, I'm trying to, okay. So this is from Monette, and Monette, maybe you could elaborate a little bit, because it looks like you are, I'm not familiar with Bonanza. So if this is the publisher, then you're talking about the books being turned over to Bonanza when you die, and the lawyer hasn't executed the document yet. So maybe you could rephrase that one for me, if you wouldn't mind, and I'll go on to some of these other ones. Okay, here's another question. So do you have both a will and a revocable living trust with the will as part of the trust? So the answer is no. The revocable living trust is a separate document from the will. Now, a person can have multiple revocable living trusts if they want, or they can have one revocable living trust, and they can also have a will. And oftentimes people have both things. When people have a revocable living trust, they will sometimes put the bulk of their assets into the trust during lifetime, their home, their brokerage accounts, their bank accounts, and so forth. The revocable living trust that I've been talking about would be a separate revocable living trust you would create exclusively to be funded with your creative property. And the purpose of that is that the trustee who would take over after your death would manage your literary estate specifically, because the trustee is somebody you entrust with that specific responsibility. But the revocable living trust is created by way of a written agreement where you're the grantor, you're creating the trust, And then you can also sign as the trustee during your life, or maybe somebody else who's going to serve as trustee right away can sign the agreement. And that brings the irrevocable living trust into force. But then the next thing that has to happen is the trust has to be funded. So actual transfers need to be made into the trust. So assigning copyright interests in the case of literary works. If it were something else like a house, then deeding the house to the trustee of the trust to be part of the trust. And then the will is something that you execute during your life, but doesn't really go into effect until it's probated by a court after your death. And you can always revoke your will during your lifetime, such as by executing a new will, by the way. And what I was also saying before is you can create a literary trust by way of a revocable living trust during your lifetime, which would live on after your death with a new trustee serving after your death, perhaps. Or you could instead have your will create what's called a testamentary trust, which would be similar in a lot of ways to the provisions of the revocable living trust, but wouldn't come into being until after your death. So I hope that's helpful. Okay, and then next question is, you have geared the bulk of this toward contracted authors. How does this change for independently published authors? I think it's rather similar, really, because let's say somebody predominantly or entirely does self-publishing. So that writer is going to own his or her own copyrights and may grant certain licenses, but usually with respect to self-published books, you maintain full control over the rights. And there are royalty streams from the sale of those works. And after your death, somebody's going to need to manage the relationships with the self-publishing intermediaries like Amazon or other intermediaries. And you are still going to want people to benefit, people you choose to benefit financially from the continued distribution and sale of your works. You're still going to want to transfer records of your business dealings relating to your career as a self-published author. So I think that what I've said applies very much to traditionally published authors and hybrid published authors, self-published authors. I think it really covers the spectrum. Okay, should the literary trustee always be an attorney who specializes in this sort of thing like you do? The answer is no. So that can be beneficial. It can be helpful where the literary trustee has a significant amount of copyright experience and licensing experience and so forth. But it also could be a family member who just has the enthusiasm and the time to spend to familiarize herself or himself with what's involved and to get the guidance of lawyers and other professionals as needed. Okay. Okay, someone also talked about assigning copyrights to, I'll say, a business entity. So maybe if you have a corporation, many authors do LLCs when they choose to have a formal business entity. Wouldn't that be a whole lot easier to transfer rights? And yes, that is a way that it could be done. So if you have an LLC, your operating agreement, the LLC could control your copyrights and your contractual rights and so forth, and then you could provide for a successor owner of your interests in the LLC or other business entity after your death. So that would be a way to do it. And also, let's say that you have a will providing for a testamentary trust. You could give your ownership interest in that business over to the literary trust under your will as another way of doing that, essentially making the literary trustee the successor in interest to your ownership of that entity. Okay, this is a great question. I'm a little confused. Do copyright termination rights not exist if they have been transmitted in a will? If that is true, does that mean that only living authors can effect copyright termination? Now, this is a really confusing thing. And I was trying to get into the many facets of this in my slide, but let me go back to it. Now, okay, let's say I'm an author. I prepare a creative work, and again, we'll take the classic author example. I enter into a book publishing agreement. So copyright termination rights under 203 apply to grants by authors. So if okay, let's say then that I'm looking to terminate the grant to the publisher 36 years after the date of first publication under that agreement. And so I have to wait until 10 years prior to the 36th year, or no later than 2 years prior. So there's this window when I can serve a valid termination notice on the grantee. And this is important. I cannot grant my copyright termination rights to anybody else so I can't give them under my will. I can't give them to a literary trust. The Copyright Act, the US Copyright Act, states the hierarchy of living heirs after an author's death who would inherit those copyright termination rights after the author dies. So the Copyright Act overrides whatever the author might try to do through a will or otherwise. Now, it might make a lot of sense to give all of my copyrights to a beneficiary or a trust under my will, but that's subject to licenses that I've granted that might be subject to termination by heirs after my death. Now, one way I can prevent that from happening is if the applicable time window arrives for me to send a valid termination notice to, say, the publisher of that book, then once I've served the notice and I record it with the Copyright Office, the future rights that are going to come back have vested in me. So then I can, they're part of my estate now, and I can give them in my will, or I can assign them to my revocable living trust during lifetime. The rights don't come back until the effective date of termination arrives, but these are future interests that at that point vest in whomever I want to give them to in my will, unless I'm still alive at the effective date of termination. It's where I didn't send a termination notice during my life, either because I neglected to do so or the applicable window for serving the notice hasn't yet arrived, that heirs would take. And I'll describe this a little further. If you're survived by only a spouse and no children, then the spouse owns the rights of termination 100%. If you're survived by a spouse and all of your children, then the spouse owns 50%, the children own the remaining 50% in equal shares. But then they'd have to pull together at least 51% of the interests. So, sign on to a termination notice together to serve a notice of termination on a grantee or a grantee's successor. And then if one of your children predeceases you and has their own children, then those grandchildren of yours would take ownership of that deceased child's share in equal shares, and then a majority of them would have to act together to exercise that share. And then if you're not survived by any spouse, children, or grandchildren, then it's your estate representative who does control any termination right after death. So your executor, your trustee. Okay, so I hope that clarified. I know it's a mouthful, but anybody can feel free, by the way. And what I will do, I don't want to lose these questions. At some point, I'll put up the last slide so you can see my contact information. And please feel free to reach out with any follow-up questions. Okay. Okay. What if your self-published work does not have an official copyright? Can it be included in your estate? Okay. So yes, when an author in the US fixes their expression in a tangible medium of expression, and that can mean typing words onto a page and storing that document and printing it, then the work is fixed and it automatically is entitled to copyright protection. So it is usually a good idea to register your copyright with the US Copyright Office. It gives you some special protections and also evidence of your ownership. So, but if you don't have a registration certificate, then yes, you own a copyright now, and you can make it part of your literary estate, which you transfer at death. Okay, I'm kind of, let's see, just to keep moving, I'm going to jump around a little. Okay, how can contracts and copyrights be transferred to a revocable living trust during the author's lifetime? Well, that's done by way of a written assignment. So the language looks somewhat like the language that you see in agreements that you execute with publishers and other licensees, except it's a full-fledged assignment of all of the rights. It's not a license for a limited period of time or something like that. Now, if you're the trustee of your revocable living trust and you later decide, you know what, I'm going to shut down the trust, I want to do something different, then you as the trustee can assign those rights back to yourself during your lifetime. It's only when you pass away that the revocable living trust becomes irrevocable, and the trustee has to do whatever the revocable living trust agreement directs the trustee to do. Okay, and then can beneficiaries paid on death be designated on copyrights to avoid them being controlled by the will, thus avoiding probate? I'd have to think further about that. I can't think off the top of my head how that would be done. You can do things like in the Authors Guild, I don't know if I've mentioned, but the Guild has a really good provision in its model book publishing contract that provides if the author dies when the publishing agreement is still in effect, then whoever stands in the shoes of the authors legally, the author's executor or other estate representative, has all of the same rights under the agreement that the author does. And so has the right to collect the royalties and sub-rights licensing revenues from the agreement, has the right to any not statutory termination rights, but rights to terminate the contract because, again, maybe the book went out of print, or can terminate certain licenses that weren't exercised under the agreement, like subsidiary rights licenses aren't granted by the publisher to third parties within a certain period of time. Whatever the case is, then by having this provision in your will, you could have this other person step into your shoes vis-a-vis the agreement. But I've been talking more on a macro scale where if you want to have an outright beneficiary of your literary estate, you would give everything to that person, the rights under your agreement, your copyrights, and all of the other things that I mentioned in that sort of laundry list of things that can make up your literary estate. Okay. At what level of income is it advisable to set up a literary trust in the case of multiple beneficiaries? I think that even where your copyrights and your associated agreements don't generate massive income, I still think it can make sense. If there is somebody who is willing to serve as literary trustee, and again, that 15% agents commission sort of compensation for the literary trustee could work very well for, maybe there's a family member of yours who wouldn't want to be in it to make money, but would, take a percentage-based compensation for whatever money is generated. And their role might be more to tend to and care for your literary legacy by being in charge of these properties. And again, maybe not having disagreements among co-owners that you would make outright beneficiaries. Okay. I recently discovered that my publisher transferred the rights to a UK publisher. How can I retrieve my work from both? And how do I include this publication in a literary trust? Well, okay, you would have to look at what the nature, you should try to get from your publisher a copy of the agreement that they executed, or at least a description of the terms of this transfer. So whether it was an outright transfer or a short-term license to publish the work in the UK and other English language territories, perhaps. So, and also look closely at whether your agreement with your publisher authorized this other agreement. And then you can determine whether and how soon those rights can be expected to come back. And then in terms of how to retrieve rights from your publisher, that's going to be controlled by your publishing agreement. Some agreements have a term of years, but oftentimes with book publishing agreements, particularly traditional book publishers, it's a life of copyright grant unless something else happens first, like the book goes out of print, or if you've been able to negotiate for it, semi-annual sales or annual sales before fall below a certain level, giving you the right to get the rights back, and perhaps certain other provisions. So you'd really have to look at that. And feel free to reach out to me if you want to share any further information with me, and I can provide some guidance. The Authors Guild also provides extensive guidance with respect to such issues. Okay. Another question, do I need to set up an LLC or an S Corp? Now, this is something that I'd say authors certainly don't need to do these things. And one drawback with an LLC is that where you have a single owner LLC, like an author LLC, you might not be shielded from the limited liability protections that an LLC can otherwise afford to members of an LLC, because the things that you're doing or the things that the LLC is doing are all traceable back to your own actions. So you're writing the manuscript for the book, and if somebody makes a claim, whether it's a frivolous claim or not, that your book defames them or infringes their copyright or something, then that would be traceable to your actions in creating the manuscript. And other things that you would do as an author managing your own LLC. Some authors do it for kind of the cachet of having an LLC designation for their business. And then also you could talk to tax professionals about any tax benefits from either one of these options based on your particular circumstances. I think that would particularly apply to an S Corp. Okay. Can you speak to the pros and cons in naming an author's agent as a literary executor and or trustee? Well, the first question would be whether the agent would be willing to do this. I think there could be benefits to it, certainly because of the agent's expertise in this area. It would have to be an agent that you really trusted, and during your lifetime, if you have a written agreement with your agent, then that's going to control how, if you become dissatisfied at some point with your agent's services, whether you can terminate the agency and what your and your agent's respective rights are thereafter. And it would be different if you provided, say, for a testamentary literary trust, naming your agent as the trustee. So, but I think that yes, the short answer is I think that there could be some pros, and the cons might be if you are not 100% sure that your agent is going to provide satisfactory services for the full term of the agent's service after your death as literary trustee. Okay. Okay, how can digital assets be transferred to irrevocable living trust during the author's lifetime? Well, you could basically prepare some kind of a writing. You can authorize your trustee to collect and manage your digital assets. You would need some kind of writing stating your intention for the trustee to control the digital assets. And then if you needed a service provider to assist with the transfer, then you would provide such documentation to the service provider, and then find out by way of the service provider's response whether it needed any additional information. And if you're again, oftentimes the author will be the trustee during lifetime of the revocable living trust, so could manage the accounts during life, and then and also as kind of a de facto making the assets part of the trust, again, share authentication information, share usernames and passwords and so forth. Okay.
Hey, Johnny here. I just wanted to say to everybody, we've gotten dozens of questions, so we won't be able to get to all of them. I'm sure you might want to answer one or two more interesting questions.
Yeah, we're getting about 20 minutes past the hour, and I appreciate all the questions. You know what? Why don't let me try to put this last slide back up. Okay, so I'm going to go new share. I'm going to go back to the slides.
Yes, that'd be great.
Okay, there we go. So there is all of my information. Feel free to call me or email me, and I'll answer questions that I'm not able to get to today. Let me take a look and see if maybe there's one more.
And also, everyone, we will have a recording of this. It takes a few hours for that to get processed, but we will have a recording available so you can review everything later at your leisure. Okay, here's another question. I'm arranging for my literary estate papers, manuscripts, and correspondence to be given to a library archive. Can I do this, but still have a revocable living trust for the financial aspects of my career, the royalties, revenues, copyrights, etc.? Absolutely. The documents, to the extent that your trustee after your death might need to look at some of these documents so as to best manage your literary estate, you can make copies of these things and you can give the originals to the archive, but you're only giving, and you would make this very clear in a written document, that you're only giving the physical papers, manuscripts, and so forth, not the copyrights to those materials. The copyrights you would transfer into your trust, and those would be owned by the trust and managed by your literary trustee after your death, generating the royalties, revenues, and so forth. Okay, well, thank you all so much. I look forward to hearing from people in the future, and thanks to you, Johnny. I really enjoyed giving the talk. Thank you so much, Edward. This was fantastic. I'm sure we all learned a lot. You've all got Ed's contact info there on the screen. You're also free to email staff@authorsguild.org, and Authors Guild members can request legal advice from us as well. And we'll have that recording out by tomorrow.
Okay, excellent.
All right. Thanks again, Ed. Thanks everyone for coming. Have a good day.